I think just like from the regulation of this problem item of MSC 6
Yes, Mr. Moa,
Lordship.
This is, have you brought the file?
Lordship.
Yes, good. I think you were deeply engrossed with the MSC Appeal 6, 2011. Because what MSC 5, 2011. Because what I see is that in MSC Appeal 6, 2011.
Lordship.
You have copy pasted 2005.
Lordship.
So unless that correction is there,
Lordship.
it will be difficult for this court also. Lordship. You should have gone through. I did not actually, I also did not make the difference between the injured and the deceased.
Lordship. Lordship.
So when
And
throughout your appeal,
Yes, yes.
you have actually used the word desist.
Yes, Lordship. That was also noticed
I-
at the time of hearing, Lordship.
I thought that it may not be proper for me
Lordship.
to actually just write the judgment. So can you make the correction now?
Sure, Lordship.
And regarding the profession also, you have given the vocation of the deceased in this MSc 6/2021.
Lordship.
You have given the vocation of the deceased in MSc 5/2021.
Lordship. If I may be allowed to make necessary corrections, Lordship. Yeah.
Yes, so I have just underlined with the pencil. Where's the second copy? So I think there are about 15 words which you have to replace. No, MSc 6, part 2. Yes.
If this honorable court allows, can it be by handwritten corrections, Lordship?
It's all right, it's all right. You just sign.
Lordship.
Wherever the word disease appears,
Lordship. Lordship.
you write injured and then you sign it.
Lordship.
And then on the vocation of vocation also, I think
Lordship. Lordship.
there is something wrong there.
Lordship.
You have pasted the vocation of the disease in MSc Appeal 5 in this MSc.
Lordship.
Appeal 6. So you make your correction, you sign it. Okay?
Lordship.
May it please your lordship.
Yes.
Otherwise also, if I'm not mistaken, I have submitted the gist. So if I can provide in both the cases,
Gist.
yes, your lordship.
That's all right. If you want to submit, there is no
Lordship.
problem. But the
Lordship.
main problem is with the correction.
Yes, lordship.
So you can correct now.
Lordship.
You can sign it. Okay.
Lordship.
And we can allow this.
Obliged, your lordship.
Obliged. Obliged.
For motion, item 3, WPC 79, PG 23.
Yes, ma'am.
May I please, Your Lordship? Lordship, this instant petition is for praying for regularization of service under Office Memorandum dated 17/03/2015.
Under which office memorandum? 17/3/2015.
Yes, Your Lordship.
Okay.
And for non-consideration of the petitioner's representation dated 17/01/2022. That the petitioner preferred the writ petition registered and numbered as WPC 64/2022, which was disposed by the Honorable Court by order dated 06/04/2022. Directing the respondent authorities, more particularly the respondents number 2 and 3, to consider the case, to consider and dispose of the petitioner's representation dated 17/01/2022 within a period of 2 months from the date of receipt of a certified copy of the order. The respondent authorities, having considered the case of the petitioner in pursuance of the Honorable Court order dated 06/04/2022 by letter dated 11/05/2022, informed the petitioner inter alia that his name, along with similarly situated work-charged employees, were put up to the government for regularization and absorption on 25/11/2021. This Honorable Court also had by the same order in Annexure G, page 23, Your Lordship. Last para, if I may be able to read. Page 23. A copy of the order to be passed by the respondent number 2 and 3 shall be furnished to the petitioner. It is needless to observe herein that
You are reading which para, ma'am?
last para,
No, which page?
23.
Page. Let me see. Page 20. Okay.
It is needless to observe herein that in the event wherein the petitioner is still aggrieved with the order to be passed by the respondent authorities concerned, it shall be open for him to approach this court again. So accordingly, for non-compliance of the order dated 06/04/2022, we approached before this honorable court for a direction to consider the petitioner's case for regularization under the provisions of the office memorandum dated 17/03/2015.
What does OM 17/3/2015 says?
Lordship, it's in page 17, annexure E. Clause 1, subclause 1. That all existing work charged and casual employees of various departments who are enjoying scale pay and who have completed 30 years or more continuous service as on 1/1/2015 will be regularized by conversion of their posts into regular ones personal to them and subject to fulfillment of condition as indicated in the memorandum. Clause 1 H2 of the memorandum further provides that the cases of work charged and casual employees in scale pay and who have completed or will complete 30 years of continuous service after 1/1/2015 will be taken up for regularization in 2 batches as on 1st July and 1st January every year.
In which post are you now serving?
The petitioner was initially appointed as skill kalasi on date 18/1/1991 and was promoted to WC skilled kalasi and granted.
Is it are you getting scale of pay?
Yes, yes, Your Lordship.
And for how many years you have been serving?
32 years, Your Lordship.
32. Heard. Your good name?
Hassan S. Longkumer.
MS. So. The learned counsel for the petitioner. So. The case of the petitioner in brief is that. He was first appointed as skill kalasi in the fixed pay of rupees 450 per month PM under the Public Health Engineering Department, wide order dated 18/1/1991. Stop. Subsequently, the petitioner was promoted to W/C, skill kalasi and granted scale of pay by the order dated 24/2/1994. Stop. Thereafter, by the order dated 2/12/2016, the petitioner was promoted to the post of W/C feature grade 2 and posted under the executive engineer PhD urban division Kohima. Stop. It is the case of the petitioner that he has completed 30 years of work charge service and therefore eligible to be considered for regularization in terms of the office memorandum dated 17/3/2015 15. Stop. It is the case of the petitioner that despite completing 30 years of service, since his service was not regularized, the petitioner submitted the representation dated 17/1/2022, praying for regularization of his service. However, the same did not evoke any response. Stop. The petitioner accordingly filed WPC 64/2022, which was disposed by this court by order dated 6/4/2022, directing the respondent authorities, more particularly the respondent number 2 and 3, to consider and dispose the petitioner's representation within a period of 2 months from the date of receipt of the certified copy of the order. Stop. It is the case of the petitioner that the department has considered the case of the petitioner for regularization, and by the letter dated 11/5/2022, the department has informed the petitioner that his name, along with similarly circumstanced work charge employees, has been put up to the government for regularization and absorption on 25/11/2021. Stop. However, till date, no action has been forthcoming from the government. Stop. Being aggrieved, the petitioner has filed the present representation. Issue notice to the respondents, returnable within 4 weeks. Mr. Tiba.
May I please, Your Lordship, sorry for interrupt. My lord, my submission is, since the state respondents are under consideration of the petitioner case.
Mr. Tiba, the learned government advocate accepts notice on behalf of the respondent number
All the respondents.
1, 2, 3, and 4.
Yes.
The learned counsel for the petitioner shall serve requisite copies of the writ petition to the learned government advocate. When? When can you serve?
Within 2 days, Lordship.
Within a period of 3 days from today. Listed after 4 weeks.
Item 4, WPC 80/2023.
May I please, Your Lordship?
Yes, ma'am.
Your Lordship, I'm praying for appointment on compassionate ground.
Oh,
Your Lordship, here the petitioner father late Sri Chingkap Panyak died in harness on 16 December 2018, Your Lordship. I've submitted my representation, and accordingly, my representation was forwarded by the Deputy Commissioner Mon on 25.
where's your representation, ma'am? Where's your representation?
Annexure 4, page 18.
Annexure 4, page
Page 18.
18. Okay. Yes, please read.
Your Lordship,
Please read.
to the Deputy Commissioner Mon Nagaland, subject application for the post of Tabasi, replacing my father Sri Chingkap DB Tabasi. Sir, with reference to subject cited above, I, Mr. Chingo Konyak, son of late Chingkap DB, would like to lay down some few lines for your kind favor and necessary action. That, sir, my father Chingkap, who was serving as Tabasi in Monhead, has expired on 16 December 2018. I therefore would like to put forward my candidature for the post of Tabasi, replacing my father. Therefore, it is my earnest request to your higher authority to kindly look into matter on compassionate ground, Your Lordship. Accordingly,
What was the response of the?
my representation was forwarded by the Commissioner to the Commissioner, Your Lordship.
To the commission?
Yes, Annexure 6, page 24.
Annexure 6, page 24. Yes, ma'am.
To the Commissioner Nagaland Kohima, subject application for compassionate appointment in respect of Sri C. Chingo Konyak, son of late Chinkap Konyak Tobasi. I have the honor to forward here with application along with duly fill up format in respect of Sri C. Chingo Konyak, who is applying for the post of Tobasi on compassionate ground against the vacancy caused by the demise of his father late Sri Chinkap Konyak Tobasi under the establishment of Deputy Commissioner Mon, will expire on 16/12/2018. All requirements as per ON number such and such dated 17 August 2015 have been fulfilled. Hence, the application is recommended for necessary action, please, Your Lordship.
What is the scheme for compassionate appointment? Is it, this is your page 34? Is it your page 34?
Your Lordship, compassionate appointment is annexure 9, page 34, yes. Your Lordship, I have also filed an RTA application.
Yes.
And by RTA application dated 13 April 2023, I've received enclosing the vacancy list of grade 4 posts as on April 2023, Your Lordship.
Have you enclosed?
Your Lordship,
Have you enclosed here?
Your Lordship, page 28.
So what is the position?
Your Lordship, my humble prayer is to kindly direct the state respondents to appoint me to the post of Dobasi or any of the present vacant posts as on April 2023 list, Your Lordship.
MS.
Yes, Chairman.
So, the learned counsel for the petitioner. So, this application has been filed, this petition has been filed. Seeking for compassionate appointment. So, it is the case of the petitioner that his father died in harness on 16/12/2018 while serving as the Bashi Grade 2 under the establishment of Deputy Commissioner Mon Nagaland. The petitioner accordingly submitted an application dated nil to the Deputy Commissioner Mon for appointment to the post of Dubashi on compassionate ground against the vacancy caused by the death of his father. Stop. The petitioner's application was forwarded by the Deputy Commissioner to the Commissioner Nagaland by later dated 25/1/2019 for necessary action. So, however, despite the representation, the respondents have not considered the case of the petitioner for appointment on compassionate ground. It is the case of the petitioner that in terms of the office memorandum dated 17/9/2015, which is the revised compassionate appointment scheme of the state government employees who died in harness, the petitioner has a right to be considered to any grade 4 post. Stop. Being aggrieved by non-consideration of the petitioner's representation, the petitioner is before this court. Stop. Issue notice to the respondents, returnable within 4 weeks. MS so-and-so, the learned government advocate accepts notice on behalf of
All the respondents.
all the respondents. The learned counsel for the petitioner shall serve requisite copies of the writ petition to the learned state council within a period of
2 days.
3 days from today. Listed accordingly. Okay.
So,
Petition item 5, WPC 33/2020.
Yes, Mr. Moa, Lord.
Lordship, the matter pertains to regularization of contingency employee, Lordship. The petitioner herein, she has put in 33 years of service, Lordship, and she's still in service, Lordship.
She is still in service.
She is still in service, Lordship.
So you are seeking for regularization.
Regularization, Lordship. I'll be relying on the decision rendered by a division bench of this honorable court, wherein in a similar case, contingency employee, it has held that OM 2015 covers even the contingency employees, Lordship. However, in that particular case, the petitioners, they were 6 altogether.
No,
They have not completed 30 years of
they have not
service.
completed 30 years of service. That is why the application petition was rejected.
Lordship,
You have completed 30 years.
30 years.
Yes, Mr. Moa. Since the petitioner has completed 30 years, why don't you consider?
You are well aware of this OM 17 March 2017. It speaks about this regularization and absorption of work charge in casual employees. As to the stand up to state, your lordship, it is very clear.
Now, okay. Tell this court what is the difference between contingency and casual? What is the difference between contingency and casual?
Contingency. If we see the dictionary, your lordship, it's a by chance.
It's upon happening of some events.
Yes.
But in service matter, whether that term will strictly apply, contingency, and you have actually utilized the service of this poor petitioner for over 30 years.
That I admit, that I admit, but.
You are a welfare state.
That I admit, that I admit, but there, in absence of any specific policy framed by the state, how can?
That is one aspect of the matter. The other aspect is you have utilized the service for 33 years. 33 years. And all his youth, you have utilized all his youth, and during his old age, you say you go empty-handed. Okay, go. How can that be? How can a welfare state treat its employee in that manner?
At the time of his appointment, the petitioner's appointment, petitioner has accepted that very thing.
The petitioner does not have the bargaining power. She has to accept the post to feed herself and her family. She does not have the bargaining power. If actually it was on contingency, okay, you were appointed on contingency, this thing has happened, and we no longer require your service, so you please leave the job. That would have sufficed.
It's a very simple thing, your lordship.
It's not simple as you say. It's not simple.
No, if your lordship say that casual employees includes contingency also.
That
is,
has been upheld by the division bench. How can this court go against? Let's see the division bench order.
lordship.
What is the relevant part?
Lordship, paragraph 4, Lordship,
Paragraph?
paragraph 4. Lordship will find at page 3.
Which case? This is WA 6.
Read appealed 6 of 2022, Lordship. Paragraph 4. Paragraph 4 is about the facts to show that the petitioners in that case, they were serving as contingency employees, Lordship.
Okay.
Paragraph 4. If your Lordship got it, may I read the Lordship? Paragraph 4, Lordship. The case set out by the read petitioners, who were 6 in numbers, was that the petitioner number 1 was initially appointed as driver on contingency basis on a monthly wage of rupees 1,500 and temporarily attached with senior accounts officer in the state planning machinery under the planning and coordination department, Nagaland, Kohima, white order so-and-so. The petitioner number 2 was also appointed as driver on contingency basis on monthly wage of so-and-so, so-and-so. The petitioner number 3 was also initially appointed as driver on fixed honorarium basis of rupees 4,500 under the planning and coordination department white order dated so-and-so. In similar terms, the respondent numbers 4, 5, and 6 were also appointed as driver on contingency basis, Lordship. For a moment, if I may be allowed to refer to paragraph 5, Lordship. Paragraph 5. It was the case of the petitioners that they were entitled to regularization in terms of office memorandum dated 17 March 2015. This is important, Lordship. Along with office memorandum dated 22/9/2004. That is the relevant portion, Lordship. That was the case, Lordship. Now, what this honorable division bench has held starts from paragraph 19, Lordship. Page number 17. Paragraph 19, Lordship. If Lordship got it.
Yes.
Now the next question, therefore, arises as to whether the office memorandum dated 17 March 2013 has extended the office memorandum to 22/9/2004, even to casual/contingency employees. By virtue of clause 1(3) of the office memorandum, clause 1(3) of the office memorandum is quoted herein below. The existing scheme for regularization of work church employees against normal vacancies being modified, and the quota for work church employees stands enhanced from 50% to 67% for the next 5 years. Effective from 1/1/2015, the existing schemes will also be applicable for the casual employees appointed on full-time basis. Paragraph 20. From the perusal of the said clause 1(3) as quoted herein above, it will be clearly show that the first part of the said clause categorically relates to the regularization of work church employees against normal vacancy to be modified in the quota of work church employees would stand enhanced from 50 to 67% for the next 5 years, effective from 1/1/15, meaning thereby that a quota which was 50% earlier, which was reserved for regularization, was enhanced to 67% for a period of 5 years, with effect from 1/1/15, and thereupon the quota 50% has been mandated in the office memorandum 22/9/2004 shall again be applicable. This aspect of the matter would be further clear from reading of clause 3 and 4 of the office memorandum 2004, whereby 50% of the future vacancies were filled up by way of regularization. Therefore, by virtue of clause 3 and 4 of the office memorandum 2004, read with clause 1(3) of the office memorandum 2015, would therefore mean that a quota for 50%, which was fixed as per the office memorandum dated 2004, will be enhanced to 67% for a period of 5 years, with effect from 1/1/15, and thereupon be effective from till 1/1/2020 would be again reverted back to 50%. 21, paragraph 21, Lordship. The contention made by the learned counsel for the petitioners, read appellants in read appeal number 15, is that in view of the second sentence in clause 1(3), the office memorandum dated 2015, this existing scheme will also be applicable for casual employees appointed on full-time basis, would mean that irrespective of the petitioners, read appellants in read appeal number 15, having not completed 30 years or more, which was a requirement in terms with clause 1 Roman 1 of the office memorandum 2015, but by virtue of the office memorandum dated 22nd/9/2004, being made applicable, the requirement of 30 years or more as on 1/1/15 was dispensed with. This argument, though looks attractive at the first blush, but in the opinion of this court, the said argument is misconceived from the reasons stated herein after. 22. A reading of the office memorandum dated 2015 would show the object behind the office memorandum 17 March 2015, wherein it has been mentioned that upon due consideration to the report of Work, Church and Casual Employees Commission and in compliance with the judgment and order of this court, the governor of Nagaland has introduced a scheme for regularization and absorption of work, church and casual employees and revision of pay and wages subject to the conditions therein. Therefore, by the office memorandum dated 17 March 2015, all other schemes for regularization, including the scheme for regularization of work, church employees brought into effect by office memorandum dated 22/9/2004, stood affected and modified by the office memorandum dated 17 March 2015. Clause 1 of the said office memorandum dated 17 March 15 stipulates how the regularization is in service is to be made. A cursory glance of the clause 1 on the face of it would show that this clause relates not only to casual employees, but also to all work church employees, meaning thereby the office memorandum dated 22/9/4 is made subject to the office memorandum dated 2015. Clause 1 Roman 1 stipulates the various conditions which needs to be fulfilled for the purpose of being regularized in respect of all existing work church and casual employees of various departments. Clause 1 Roman 1 being relevant as therefore quoted here and below. Regularization of service. All existing work church and casual employees of various departments who are enjoying skill pay and who have completed 30 years or more service as on 1/1/15 will be regularized by conversion of the post into regular ones personal to them and subject to fulfillment of conditions as indicated below. A, incumbent concern and his or her service rendered as work church employee has been duly verified and found genuine by the district level verification committee constituted by the government. B, availability of service records, including appointment order, date of initial appointment, proof of length of service, etc. Their suitability for continuation in service to be recommended by the heads of department concerned. D, the post occupied by them on regularization shall automatically stand abolished as and when they vacate the post on retirement, resignation, death. The strength of work church and casual employees under various departments shall stand reduced by equal number concurrently with the regularization of such employees. No fresh appointment shall be made against this post. E, on regularization in service, the pay of incumbents shall be fixed at a minimum of corresponding pay band and so and so, so and so. If the past service renders.
Okay, where is that observation which says that the scheme will also cover contingency employees?
30, Lordship. Para 30.
Para? Para?
30.
30. Okay.
Page 27, the second last page, Lordship. On
Para,
discussing.
just wait, Mr. Para 30.
30, yes, Lordship.
Just wait.
Second last page, page 27.
Just wait. Para 30, let us read.
Lordship. So the discussion was made from para 19 to 29 about OM 2015. 30, on the basis of the above findings, an important issue further arises for consideration as to whether the posts which have fallen vacant in view of the setting aside of the appointments of the respondent numbers 3 and 4, the appellants in read appeal 6 are required to be taken into consideration for regularization of the services of the petitioners. The appellants in read appeal number 15 of 2022 or the said posts are required to be filled up in terms with the direct recruitment by the NPS. Clause 1 Roman 2 of the office memorandum dated 17 March 2015 stipulates that it is applicable to those work church and casual who have completed or will complete 30 years of continuous service after 1/1/15, meaning thereby the right of the petitioners appellants to be regularized will also arise after they render 30 years of continuous service. And at present, the petitioners are yet to complete the 30 years of service. Taking into account the petitioners at present are not eligible, this court cannot issue a mandamus directing the respondent state to keep the post vacant till the petitioners become eligible. The respondent state will be at liberty to take such course of action as deemed fit as per its existing policy. Now it is very clear that the factual position is that all the 6 appellants, they were appointed on contingency basis. The Honorable Division Bench has made an observation that though they are applicable, the OM is applicable, but they are not eligible for one of length of 30 years of service.
Yes, Mr. Moa, how do we overcome this? How do we overcome this? You get you prepare yourself and come to argue. We'll fix it on 29th for admission here. See, just help this court by actually making a submission on the difference between contingency, casual.
Yes.
Okay. Because so far as this court is concerned, all this work charge, casual, contingency, all these are fortuitous appointments. They fall within the same class. So just because the appointment order says contingency, it might be also, it doesn't mean that actually the scheme will not be applicable. But you can come prepared. Let us hear you also. We'll hear you.
Yeah, in this case, I was the counsel for the state. I have read it.
So you come prepared. You come prepared. You come if you can actually satisfy this court on the difference between contingency and casual, to say that this judgment will not be applicable because of the views of the Honorable Supreme Court in this case. You can come with that kind of argument. Let us see. We'll sit on 29th.
Lordship, otherwise, there is also a similar case, Lordship, rendered by this Honorable Court. I have also realized contingency, Lordship. You know those case, Lordship. Read the application number 112 of 2019. Judgment and order was passed on 16/9/2020.
You serve the copies to Mr. Mo.
Lordship.
Okay, so that
Lordship.
they can also come prepared.
Lordship.
Because
I'll finish copies during the course of the day, Lordship.
actually we expect the learned senior government advocate to assist this court.
Lordship.
Okay, not to just jump into the issue, but to assist this court. Okay, so you give a copy of the judgment to him also. Let him also go through.
During the course of the
And
day,
let him also address the court on
Lordship.
29th. Okay,
Lordship.
what is 29? 29 is Monday. Yes,
Lordship.
on the prayer of the learned counsel for the parties, listed for admission hearing on 29/5/2023. Okay, please come prepared. Okay.
Vice Lordship.
Item 6, WPC 7, 2021.
Item 6.
May I please, Lordship? My lord,
Yes.
I'm mentioning on behalf of MD Imsong, additional AG. Kindly allow 2 weeks time to file affidavit.
Okay,
Okay, Lordship.
Mr. E. Tipa. The government advocate makes a mention on behalf of Mr. M.T. Imsong, the learned additional advocate general Nagaland, and seeks adjournment of the case for 2 weeks for filing affidavit in opposition on behalf of the state respondents.
Lordship,
Prayer is allowed, listed after 2 weeks.
the interim may continue.
Now, the interim order passed earlier shall continue till the next returnable date. Okay.
Much.
Item 7, WPC 200, 2022.
Yes, Mr. What is it?
Lordship. Is to respond to file counter.
Okay.
And filing counter affidavit, Lordship,
Yes.
is to respond and clarified.
Yeah.
On what basis the respondent was appointed and commissioned ground. This also made a pertains to appointment and commissioned ground, Lordship.
Yeah.
The petitioner husband expired in the year 2013, was serving us to a secret too. She applied for commissioned appointment. And your Lordship knows, as for the scheme, commissioned appointment should be given unregarded.
What is the stand of the government? What is the stand of the government?
Lordship,
You have actually filed this application for appointment on completion ground.
regular appointment. I am on contingency now.
You are on contingency.
Your Lordship. And when the vacancy arose in the year 2018, instead of considering my case regular, The brevet respondent was appointed without
What,
legal office.
what is your position?
Continue, Your Lordship.
No, what is your position in the seniority list? For appointment on compassionate ground? Because I think the department maintains a list.
Yes,
The
Lordship.
department maintains a list.
Lordship, it is admitted fact that the petitioner.
Have you given the list?
Lordship,
Lordship.
I'm appearing on behalf of Ms. Pichano, Lordship.
Where's Pichano?
She's indisposed, Lordship.
Whether the government has given the list
Lordship.
and whether you are in that list, number one.
No, Lordship. That's why I'm trying to project the facts of the case, Lordship.
So why don't you file a reply?
Already filed, Lordship.
Reply file. Okay.
And Lordship, one aspect of the matter, Lordship, at present, there are more than 2 vacancies available under this establishment. So, Lordship, instead of,
Let the government advocate come. We will hear. We will,
Lordship,
because afterwards they may say that they are prejudiced. Much opportunity was given to them. Let us hear the government. MS so and so submits that. MS Pichano, the learned government advocate for the state respondents in the case, is indisposed and therefore seeks for a week's adjournment. Prayer is allowed. Listed after a week.
quiet machinery, Lordship.
Listed after a week for admission. I don't know whether actually what is this 22, because we have 17, 16, 17 cases which is pending. Listed for listed up to 2 weeks for admission hearing.
Lordship.
Okay.
Item 8, WPC 206/2020.
I have received affidavit in opposition from the government side. I may be given 2 weeks' time to make a small reply.
Mr. Kimti Longcha, the learned counsel for the petitioner, submits that he may be allowed 2 weeks' time to file affidavit in reply to the affidavit in opposition filed by state respondents.
Mother,
Prayer is allowed. Listed accordingly.
much obliged.
Item 9, WPC 223/2022.
May I please, Your Lordship? Lordship, kindly grant us 3 weeks' time to file affidavit in reply filed by the respondent.
Because you have,
Yes, my lord. No objection.
so affidavit in reply to the affidavit in opposition filed by the
Filed by
state
the government,
respondent.
yes, Lordship.
MS Sanso, the learned counsel for the petitioner, 6 for
3 weeks. time.
3 weeks' time to file affidavit in reply to the affidavit in opposition filed by the state respondents. Prayer is listed accordingly. Okay.
Much obliged.
Much obliged.
Item 10.1, WPC 251.
What is this, Mr. N. Angami?
Lordship, the petitioner, in all this case, the petitioner actually were released from service on account of submission of a fake document,
Okay.
Lordship. Now, Your Lordship, the item 10 to 14, I have already filed my contract affidavit,
Item
10 to 14.
10 to 14. Okay.
Lordship, 15 to 21, I have already received the paragraph comment, Your Lordship, and the affidavit is under preparation
15 to,
to 21, my Lord.
oh, 21 is the last case.
Yes, my Lord.
Okay, so you need some time.
Yes, to file my contract affidavit in 15 to 21, my Lord.
Okay, how much time?
3 weeks' time if.
Okay, and Mr. I. Jamir, you are for?
I'm appearing on behalf of my senior team.
No, you are for which respondents or?
No, petitioner in from item 15 to 21. Your Lordship.
Okay. And Mr. CT is for?
10 to 14.
Correct, huh? Okay. Okay, we give government time. 2 weeks time.
3 weeks' time, Your Lordship.
Okay. Mr. N. Angami, the learned senior government advocate. 6/4, 3 weeks time to file affidavit in opposition in WPC 259/2022, WPC 260/2022, WPC 261/2022, WPC 262/2022, WPC 263/2022, WPC 264/2022, and WPC 265/2022. Stop. The learned senior government advocate submits that affidavit in opposition on behalf of the state government has already been filed in item 10 to 14. Listed after 3 weeks.
Lordship.
Okay?
Deeply obliged. Well, no, I'm seeking for.